started going through, and the first C he ran across instead of running across this other man was Branton. So that afternoon, there was an order on the bulletin board, Leo Branton Jr. is hereby transferred immediately forthwith to the 92nd Infantry Division, which was also on maneuvers at the time, getting ready to go into combat. So that's how I joined the Infantry Division, went overseas and was in combat with that division for, I don't know how many months it was, but until about 2 months after the war was over. Fortunately, I got there after I was sent to Italy, incidentally, after studying German. They sent me to Italy. Fortunately, I got there after the troops had invaded by landing at Anzio Beach, which was a terrible slaughter of American soldiers there. But we had already gotten up as far as Naples, Napoli, and I was with the 92nd Division from Naples on up till the time the war was over, where I ended up with a reconnaissance unit in near the Swiss border. That's my time in the United States Armed Forces.
Well, what about this movie, St. Anna's? What did you think of that?
That movie was a disgrace. It was demeaning to the 92nd Infantry Division. I think that, what's the guy, the producer's name? Spike Lee. Spike Lee should be hung up by his thumbs. He opens this thing with black soldiers marching across the river to take the other side, which was being held by the Germans. And he had these black soldiers walking through, one of them saying, "Lordy, Lordy, I ain't got no business out here. Why don't they send the white boys out here to do this?" Well, this was disgraceful. This was disgraceful. Sure, Negro soldiers hated being in combat. They didn't like being there because they knew the kind of democracy they were going to die for, and they didn't want to die for that. But yet they still followed the orders and instructions, and they fought bravely all the way, and there was no such thing as this cry out of people acting like Uncle Toms before they were going into combat.
So after you got out of the Army, what did you do?
After I got out of the Army, I went to Chicago, and I still wanted to be an actor. And so I tried out for a play, the only play that was on Broadway at the time involving Negroes was a place called Anna Lucasta. And there was a good friend of mine in Chicago who was understudy, had an understudy role, a woman, in Anna Lucasta, and she said, "Leo, there's an opening for an understudy now for Anna Lucasta. Why don't you go try out?" So I said, "Great." So I went and I tried out for the role. And when I finished, the producer said, "Mr. Branton, you're an excellent actor. However, we can't use you because you aren't Negroid enough." I said, "What do you mean by that?" He said, "Well, you know, in this play, the role that you would be playing, the man obviously has to be a Negro. He obviously has to be a Negro. But the audience looking at you from the audience, they wouldn't know whether you were a Negro or not." So then the thought occurred to me that, yeah, he's probably right about that. But there's no other role that I can play because the only people who were getting roles at that time were the people like Stephen Fetchit and people who played Amos and Andy roles and things like that. So I decided, well, I want to be an actor. So what I'll do is I'll go to law school. And I'll become a trial lawyer. Because a trial lawyer is an actor. The only difference is an actor acts on the stage, but a trial lawyer acts in the courtroom. I said, but a trial actor, a real actor, has an easy way to go. He has someone who produces the show for him. He has somebody who has written the script for him. He has somebody who directs him how to do it. But a trial lawyer must do the whole thing. He must produce his defense himself. He must direct himself. He must write think what he's going to do, and then he must perform. And so I said, therefore I can do my acting in a courtroom better than that. And that's how I decided to become a lawyer. I made an application to Northwestern University School of Law, and so I attended Northwestern. I was the only Negro in my class at Northwestern. I decided I didn't want to live in Chicago because I felt the town was too corrupt, and I decided to move to California where the pastures were greener.
What was the legal community like here when you first landed?
Oh, when I first came here, I graduated in 1948, and I came here and took the bar, and I found that there wasn't a single Negro lawyer in the city attorney's office, the district attorney's office, the attorney general's office, one black judge on the bench, no black lawyers in any of the law firms, don't mention being a partner in the law firms, they weren't even employed in a law firm. As a matter of fact, I applied to about 3 or 4 of the big law firms who handle criminal law, because that's what I wanted to do, criminal law. I took a bar review course, the Forest School bar review course, and there were about 1,500 law school students who were taking this review course, and they always graded you at the school, and the big law firms would ask the head of the bar review course to send them a list of the 10 highest students who made the highest grades. Well, I was number 1 in my class, and so my name went in. I went to these law firms, and none of them would hire me. Finally, I went to a law firm, and I don't remember the lawyer's name now. It really is not that important because he wasn't that important. But he hired me. And as I was about to walk out the door, he said, "Just a minute, let me ask you a question." He said, "What is your race?" I said, "I'm a Negro." He said, "Oh, not that it would make any difference to me." He said, "My clients would never accept a Negro lawyer. Why don't you go down on Central Avenue? There's a lawyer down there by the name of Walter Gordon. And I'm sure that Walter Gordon will give you a job." I said, "Thank you very much." I left there and I went down to see Walter Gordon. He told me, this other lawyer told me that that I looked too Negro. And I said, "Well, not before I wanted to be an actor. They said I wasn't Negroid enough." But let me change it for a minute. You know, not looking Negroid enough became great value to me during the civil rights days. I was able to go into courtrooms, into jails, into everywhere, stay in the hotels, eat at the restaurants throughout the South, because nobody suspected that I was a Negro. It's the greatest insult in the world for a white man to make a mistake and call a white man a Negro. And so I knew that nobody would dare question me, because he would think it would be an insult. So that stood me in good stead during the civil rights days.
At some point, you ran into the Bucky Walker case. What was that?
Well, I had been practicing law for about 6 months, and I read in the newspaper about a young air corpsman who was arrested in Riverside County for a double murder. And there was something in the paper. It was headline news all in Los Angeles. And all of the 3 Los Angeles papers, we had 3 of them. We had the Mirror, we had the Herald Examiner, and we had the Times. And it was all of the newspapers. So I became convinced that this kid was not guilty, and I said, "I want to go over and offer to represent him in this case." Well, I got to tell you, I also had an ulterior motive in doing that. And in addition to wanting to help him, I knew that this was going to be headline stuff, and nobody knew who I was in Los Angeles, but my name would be all over the front pages if I took this case. And so that was a plus that I got out of the case. So I went over there and I found out that never in history had there been a Negro person sitting on the jury in Riverside County. And so the first thing I did was make a motion to quash the jury panel on the grounds of systematic exclusion of Negroes from the jury. And I did that because the Supreme Court had declared it unconstitutional to have a discrimination against race in the Scottsboro case, which took place in the 30s. So I made this motion to quash the jury panel. But then two things came to me after I made the motion. All of a sudden I said, you know, this is a death penalty case. What the hell am I doing over here by myself, representing a guy in a death penalty case, and I've been practicing law for about six months. So I went to all of the Negro lawyers in town and tried to get them to join me in this case. I don't know whether I went to Walter Gordon or not, but if I had gone to him, he would have turned me down, only because he couldn't afford to be over there for a 3-month trial because he had too much going on here. But all the Negro lawyers turned it down, and I had to go by myself until finally the NAACP decided they wanted to come into the case, so they sent every reporter over to sit during the trial. He took no part in it, came over. Now, my other problem is, how do I show that there had never been a Negro to sit on a jury? Because they didn't keep any records on what kind of race, showing the race. And I looked at all the jury. But I asked a few questions around, and everybody told me they had never seen a Negro on a jury. So then what I did is something that perhaps only a young lawyer who would hit a white man in Arkansas would have nerve enough to do this. I served a subpoena on every Superior Court judge in Riverside County, and a subpoena on all of their clerks. And I started calling them to the stand. Have you ever seen a Negro on a jury? No. Have you ever seen a Negro on a jury? No. So after a full day, the judge said, I'm convinced this jury panel is quashed, and the jury commissioner is instructed to bring in a jury with a representative number of Negroes on it. And so for the first time in history, as a result of the Lawrence Bucky Walker case, lawyered by Leo Branton, Riverside County had an integrated jury.
The Smith Act, what was that?
The Smith Act. The Smith Act was a congressional, rather a federal law that made it unlawful for people to conspire to overthrow the government. And at this time, we were at the height of McCarthyism. Everybody hated the communists. And they put on trial the leaders of the Communist Party in New York and went through a long trial, and all of the defendants were convicted for conspiracy to advocate the violent overthrow of the government, and they all got 5 years, which was the maximum by law at the time. And even all of the lawyers went to jail. Now one will wonder, well, how could the lawyers go to jail? Well, the judge in that case was a tyrant. And he, at the slightest wrong move from a lawyer, would hold him in contempt of court. So all of the lawyers were held in contempt of court, and they all got jail time for being held in contempt of court. There was one black lawyer on that team, followed by the name of George Crockett, out of Detroit. I got to know George quite well. George was a member of an integrated law firm in Detroit. He, in spite of the fact that he went to jail as a result of his services in the Smith Act, he later became a judge of the court in Superior Court in Detroit, and after that he became a United States congressman. So then, flush off their victories in New York, the government decided to go after the Los Angeles, California Communist Party leaders. So they indicted 13 members of the Communist Party in California and charged them with conspiracy to advocate the violent overthrow of the government. Well, the lawyer for the Communist Party at that time was a lawyer by the name of Ben Margolis. And so Ben needed somebody to help him with the case because there were 13 defendants, and he wanted to have at least 3 or 4 other lawyers to help him. So he went to every member of the criminal courts bar in Los Angeles, and all of them turned him down, saying, no, I'm not going to represent a communist. I'll lose my other clients for representing a communist. And all the lawyers in that case went to jail. I'm not going to go to jail for any communist or anybody else. So finally someone told him that there's a young lawyer who just tried to launch Bucky Walker case in Riverside County. And he's a fantastic trial lawyer. Why don't you go to see him? So they came to me and he asked me, would you mind representing members of the Communist Party? I said, if they pay me, of course I will. So I joined that team of lawyers. We tried the case, and incidentally, he finally put together a team, but Al Weirin, who was the attorney for the ACLU, had nerve enough to join. A fellow whose name I can't recall right now, but who was head of the AFL-CIO union, he joined. A fellow who represented the Harry Bridges Longshoremen's Union up in San Francisco joined, and then there was Ben Margolis, and there was Leo Branton. We tried that case. All of the defendants were convicted. We had one lady who took the witness stand to testify for the defense, and she testified on direct examination all about her things that she had done as a communist and what she believed in as far as communism was concerned, that they did not believe in force and violence. The theory of the government was that the revolution in the Soviet Union, in Russia I should say, came about through force and violence, through the teachings of Marx and Lenin, and therefore any communist in the United States was bound to try to bring about an overthrow of this government by force and violence. Ridiculous theory, but that was their theory. She told all about what she did as a member of the Communist Party, the work that they were involved in. On cross-examination, all the United States Attorney did was ask her, is so-and-so a member of the Communist Party? She said, I will answer any questions about myself or any of my defendants who are on trial, but I'm not going to name anybody else as a communist, because I know it'll mean they're going to lose their jobs, or they're going to be harassed, suffer other things as a result of being named as a communist. So the judge told her to answer. She wouldn't answer. They held her in contempt of court. Then they asked her about 30 or 40 more names of people, and she refused to answer, and every time she refused to answer, the judge would hold her in contempt, and she got something like, she was required to stay in jail for the rest of the trial. So because she was being held in jail for the rest of the trial and everybody else was on bail, the defense decided they wouldn't call any more witnesses to testify, so we rested after she was put in jail. She stayed in jail for the rest of the trial. They were all convicted, and the case was appealed to the Ninth Circuit Court of Appeals. They upheld the conviction, and then it was also appealed to the United States Supreme Court. At the same time, the contempt citations against this lady, month after month after month, year after year after year, for all these various contempts, her case was appealed also on these contempts. So I wrote a brief in connection with my clients, and I also wrote a brief in connection with the contempt citations that were issued against Olita Yates, who was the person who refused to name names, and both appeals went to the United States Supreme Court at the same time. The United States Supreme Court reversed the main conviction, and reversed it on the grounds that these communists were only espousing their views under the First Amendment, and that there was no evidence or no clear and present dangers that they were about to overthrow the government. Under the First Amendment, they had a right to do these things, and while the law is still on the books, I suppose, no one has ever been prosecuted under that law since then. Well, I argued the contempt case before the court. I did not argue the main case because the judge would only allow 2 lawyers to argue, and Ben Margolis was one, and a fellow by the name of Robert Kinney, who was an ex-attorney general of California. We got him to argue the case, even though he wasn't in the trial. And our purpose of getting him to argue, he was Attorney General under Earl Warren. And Earl Warren is now the Chief Judge of the Supreme Court. When Bob Kennedy came in, he rose and he said, "May it please the court?" And Earl Warren said, "Yes, Judge Kennedy." And so we figured we had a little step ahead by then. So we went back to the trial court. The trial court says, "I don't know what the Supreme Court means. I gave what I thought was a fair sentence in the first place." So he sentenced her to the same sentence that he did before. I then filed a petition for the Supreme Court again to go back. The Supreme Court then, without hearing from the government, ruled that our petition for certiorari was granted and the case is ordered dismissed. And so so that was my first case in which I fought to uphold the First Amendment.
Let's talk about the FBI. What can you tell them about how you were treated and the ultimate outcome?
Well, the FBI has never been one of my favorite organizations. I figured that the FBI must have some kind of file on me because I had represented so many unpopular causes. I had represented Communist Party people. I had represented witnesses before the Un-American Activities Committee. I had represented the Black Panther Party. I had represented the Black Muslims. I had represented Angela Davis, who was an admitted member of the Communist Party. And I said, they must have a file on me. So I asked for my FBI file, and it was shocking when I got the file. The FBI first picked me up